Today, I'm going to talk about sex discrimination. When I worked at the EEOC as a federal investigator, I saw many faces of sex discrimination, including sexual harassment, pregnancy discrimination, and equal pay. Each of these forms of discrimination has their own unique standards of proof. I'll talk about each in turn. Of course, this is not legal advice. Also, I'm going to discuss less common forms of sex discrimination, including dress codes and maximum height and weight standards. You can use the chapter links in the description below to skip to the topics relevant to your situation. There are two types of sexual harassment: quid pro quo and hostile work environment. You can experience either one or both simultaneously. In Latin, quid pro quo means this for that. In the workplace, it means a supervisor offering job benefits in exchange for sexual favors. In this type of harassment, the harasser is a supervisor who has, or seems to have, authority to cause you financial harm. The supervisor requests sexual favors that are tied to a job benefit. You are forced to decide between submitting to the sexual advances or risking termination, loss of a promotion, or some other negative job-related impact. If you submit to your employer's advances, you can still have a valid claim of sexual harassment. The economic, psychological, or physical duress caused by the unequal power relationship might coerce you to submit to your employer's advances. You don't necessarily need to prove you resisted the advances, but your case is significantly weakened without evidence of rebuffed advances. The reason for this is that your employer will argue that you agreed to the relationship. A consensual relationship between a manager and an employee is not illegal. You need to prove the advances were unwelcome. If you end a consensual relationship with your manager, you must clearly notify them that further sexual conduct is unwelcome. If they continue to make sexual advances, or your boss fires you because of the breakup, most courts agree this is sexual harassment. In quid pro quo sexual harassment, the company is automatically responsible for the manager's actions. Some courts have ruled that a manager who only threatens to take an adverse action but doesn't follow through is not committing quid pro quo sexual harassment. In this situation, the manager's actions could still create a hostile work environment. Hostile work environment is an umbrella term that includes all other types of harassment where unwelcome conduct creates an abusive working environment. The unwanted sexual conduct could be from unwanted touching, or it could be from something you see, like profane pictures or crotch grabbing, or something you hear, like derogatory comments, unwelcome discussions about sexual topics, come-ons, or requests for sexual favors. Unwanted sexual conduct that is not directed at you may still contribute to an abusive working environment. Unwelcome conduct could occur at your workplace or at off-site work events, including at events that are not employer-sponsored, but where employee participation is customary or expected. To establish a hostile work environment, you need to prove the frequency and severity of the conduct is significant enough for a reasonable person to determine the work environment is hostile. Also, you must perceive the work environment to be hostile. Unlike quid pro quo, an employer is not automatically responsible for a hostile work environment. To hold your employer responsible, your employer must have known about the harassment and failed to take immediate and appropriate action. Frequency is how often the unwelcome behavior occurs. Severity is a measure of the seriousness of the behavior. Daily touching is more frequent and severe than a couple of inappropriate comments spoken by a coworker over the course of a year. Exactly what a reasonable person would have to experience to determine it was a hostile work environment is subject to interpretation. A serious touching event might be enough, while a dozen sexist comments might not. Also, you must perceive the work environment as hostile. In other words, you must prove the sexual behavior was unwanted. Frequent sexual jokes and sexual advances are not always illegal. If you act flirtatiously on the job or initiate sexually explicit conversations with coworkers, you show that you welcome this type of behavior. Submitting is not the same as initiating. Hugs initiated by a boss may be unwelcome, even if you tolerate them without protesting immediately. You do not have to explicitly tell the harasser that their advances are unwelcome if you consistently demonstrated resistance to all sexual advances or sexual conduct. The difficulty is that an ambiguous response, because of politeness, indecision, or fear, may not express rejection of the conduct. Without rejecting the advances, you cannot show they were unwelcome. The best way to establish advances are unwelcome is by telling the harasser to stop the harassment. More on that in a moment. For an employer to be liable for the harassment, they must know about the harassment. If the harasser is a coworker, you must complain of the harassment to someone in management, unless management directly observed the unwelcome behavior. Management usually learns about harassment through a complaint made by the person who was harassed. When an employer learns about harassment, it must take immediate and appropriate action. This applies to owners and managers. Employers are also responsible if the employer should have known about the harassment and failed to act. This could be because the employer's sexual harassment policy is non-existent, not enforced, or poorly disseminated. Some courts have ruled that it is unreasonable to assume that an employer with a well-defined sexual harassment policy should have known about harassment by a low-ranking manager. The best way to ensure your employer is responsible for a hostile work environment is to make a complaint. The action taken by the employer is required to be prompt and effective. Discharge of the harasser is not required for the first offense unless the harassment is quite severe. If the action taken by the employer is not sufficient to stop the behavior, the employer must take more severe action against the harasser to prevent a reoccurrence. Transferring you without your consent is not effective action. The first thing to do when sexually harassed is to tell the harasser to stop. Be firm, be clear. The harasser may not realize he's offending you. Focus the attention on yourself and explain the effect of his behavior. Like, I don't like you talking about my body, it makes me uncomfortable, and I need to do my work. Tell the harasser what you want him to do. Please stop now. Don't give any excuse like, I don't like to date coworkers, or I'm sure you were just trying to be flattering. Just tell him to stop. This is hard, very hard. Your relationship with the harasser will be awkward for a while, but if you do not cut off the harassing behavior quickly, your work life will become much more difficult. You may want to rehearse what you want to say with a friend. Repeat what you want to say several times. The more comfortable you are with what you want to say, the easier it will be to talk to the harasser. If the harasser is a supervisor, you still want to tell him to stop, but doing so could trigger retaliation against you. You'll want to confirm your conversation via text, IM, or email. Like, thanks for hearing my concerns today about how I was uncomfortable with some of the things you've said. I hope we can have a fresh start on Monday. It will be difficult to prove retaliation without documentation of your opposition to the harassment. If you have told a coworker to stop and he harasses you again, you don't need to be nice. Just simply tell him he is harassing you and to stop. Inform him that sexual harassment is illegal. If that doesn't work, or if the harasser is a supervisor and you've already told him to stop once before, it's time to complain. This is a significant step and should be taken only after verbally communicating your discomfort to the harasser. I'll discuss suggestions and strategies for complaining to management in a future video. Hit the subscribe button below so you don't miss out on getting the information you need. If you've experienced harassment, and if you're comfortable doing so, share your experiences below, especially any tips that you might have that might be helpful to others. The Pregnancy Discrimination Act was added to Title VII of the Civil Rights Act and prohibits discrimination because of pregnancy, childbirth, or related medical conditions. This prohibition applies to common acts of discrimination like hiring, firing, discipline, and promotion, as well as rarer types of discrimination. For example, an employee's health benefits for pregnancy cannot be lower than those provided for other short-term impairments. An employer must provide a reasonable accommodation to pregnant employees when needed. You may recall from the last video in this series that a reasonable accommodation is an adaptation that would allow you to perform the essential functions of your job. Examples of accommodations include schedule adjustments to attend medical appointments, or the ability to sit or eat and drink on the job when normally that is not permitted. If your employer allows employees with temporary impairments or disabilities to have light duty, disability leave, or unpaid leave, these accommodations are also available to you. To provide you with an accommodation, your employer must be aware of your need for an accommodation. Your employer will likely be unaware of your need for an accommodation until you have made a request. If a possible accommodation exists and your employer fails to provide it, that is direct evidence your employer has violated the law. You do not have to suggest exactly what accommodation would allow you to continue working, but you need to participate in a dialogue with your employer to determine what accommodations are necessary and appropriate. When the need for accommodation is not obvious, your employer can ask for medical documentation that supports your need for an accommodation. While your employer must provide a reasonable accommodation, it is not required to provide the accommodation that you prefer. Your employer does not have to provide a reasonable accommodation if it causes an undue hardship. An undue hardship is a significant difficulty or expense for the employer. Any accommodation that is unduly costly, extensive, disruptive, or fundamentally alters the nature and operation of a business causes an undue hardship. Most accommodations will not place an undue hardship on an employer. Abortion is inseparably related to pregnancy. In states where abortions are legal, it is illegal to discriminate against an employee because of her decision to have an abortion. Very restrictive leave policies may have a disparate impact on women because of the absence from work required by a pregnancy. Title VII is not the only law to prohibit salary discrimination because of sex. The Equal Pay Act also ensures equal pay for equal work. The Equal Pay Act has many loopholes and exemptions, but it also has some advantages. Under Title VII, you have to file a charge of discrimination with the Equal Employment Opportunity Commission within 180 days, or 300 days in most states. Under the Equal Pay Act, you can file directly in court within 2 years, or 3 if the discrimination is intentional. Your employer typically needs 15 employees to be covered under Title VII, but only 2 under the Equal Pay Act. When complaining about sex-based unequal pay, you can mention Title VII, the Equal Pay Act, or both. To prove discrimination against a woman, a man must have worked for the employer at some point to provide a basis for comparison, including as the predecessor or successor of the woman. There are a few less common forms of sex discrimination. Segregating is physically separating employees or facilities. Classifying is grouping employees into different jobs or job categories. An example would be only hiring women into server jobs, while men are hired as bussers or maitre d's. An employer cannot segregate or classify employees based on their sex, except for bathrooms and locker rooms. Sometimes discrimination against a woman occurs not because she is a woman, but because she is a woman and because of something else. This second factor could be a protected class, such as age or race, Or the second factor could be something not protected under federal law, like having school-aged children or being unmarried. This type of discrimination is called sex plus. Positions that members of one sex cannot perform are extremely rare, like actress or fitting room worker. In these jobs, being of a particular sex is a bona fide occupational qualification. An employer cannot enforce its dress code against only one sex, or enforce only one part of a dress code if it impacts only one sex. However, in the past, an employer could have different grooming standards for men and women. A Supreme Court ruling in 2020 prohibited discrimination based on sexual orientation or transgender status. As a result, the courts now need to address whether a dress code that has separate rules for men and women discriminates against someone who identifies as non-binary. The courts may eventually require employers to establish gender-neutral dress codes and grooming standards. Reverse discrimination. Sex-based discrimination against men does occur, but historically, it's extremely rare. One analysis found that out of more than 3,000 cases filed in federal courts, fewer than 100 alleged reverse discrimination, and in only 6 of those was discrimination established. While legal standards for discrimination are equal for men and women, fact finders realize sex discrimination laws exist chiefly to protect women. Often, a male victim of discrimination must explain why the traditional forces that act to favor men over women were reversed in that particular circumstance. We covered a lot about sex discrimination. If you would like to know more about another protected class, like race or disability, jump ahead to the appropriate video in this series. Otherwise, check out the video which discusses retaliation. You need to know how to be protected when complaining about discrimination. But before you go, was this video helpful to you? If so, please click the like button. Also, if you've experienced harassment and have any tips that might be helpful to others, please leave a note in the comments below. Thanks for tuning in.